turn it on.
Oh, okay.
Yeah, I just need it for sound. We have Altamini, we have Carter, we have Michael Drew, which is at 2:30, Emmanuel Franklin, Haseen Side, Christopher Wade,
Okay.
and Willis Needham. So I am ready whenever you are, because I think everybody's on here except for Drew.
Okay.
Yeah, I see Altamini right there too. I'm his attorney. Mr. Grant,
Yes, Your Honor.
who is your client?
My client, I'm trying to get him to log back in, is Mr. Saad, Hussein Saad.
Okay. He's not in the waiting room right now. Good afternoon, Mr. Glenn.
Good afternoon.
Okay, Mr. Glenn, you're on the one that we need to do the hearing on, right?
Right.
I don't think the officer is on yet. All right, Mr. Altamini. Have you talked to your attorney?
Yes, ma'am.
Um,
What was that?
Wait, I was asking if you talked to your attorney, but I see he's in the waiting room. I'm letting him in now. Okay, we can call.
Okay.
You're not judge. Oh, yes, you are.
Yes, sir.
What did you say?
Altamini. Mhm.
Calling case number 19008351. The people of the state of Michigan versus Mohammed Altamimi. This is scheduled for a pretrial appearances for the record, please.
Good afternoon, Your Honor. Andrea McRae appearing on behalf of the people, P number 83698. I am standing in for Mr. Ralph Elizondo with the PAT 2 unit.
And Your Honor, Marshall Goldberg on behalf of Mr. Altamimi. Mr. Altamimi, if you are driving, you need to pull over.
I'm not driving right now. I'm parked.
Okay, you're parked. Thank you.
Okay, Mr. Altamini, state your name for the record, please.
Mohammed Altamimi.
Okay, the court notes that Mr. Altamini is on the Zoom call. Do you know if there's an offer in this, Ms. McRae?
Unfortunately, I don't, Your Honor.
Your Honor, I can
Okay.
shed some light on it.
Okay, go ahead.
The last time we were in court was the day that the prosecution made an offer. It was a below guideline offer to a single count of assault with intent to do great bodily harm less than murder. The balance of the counts would be dismissed. We then had a chance to discuss it, my client's father and I. We made a counter offer. This morning, Mr. Elizondo was talking to the complaining witness to get that witness to approve the offer. So it is not set in stone, but the offer is changing to Mr. Altamimi's benefit. To that end, Your Honor, I'd ask for another date because any decisions that I make with Mr. Altamimi, because of some of the dynamics involved, will necessarily involve another family member.
Okay, all right, this is a 2019 case and the court needs to get it off its docket. So-
Yeah, there were multiple referrals to the forensic center on this, which is
Oh,
part of
okay.
the reason that I made the comment I just did earlier.
Okay, all right, I'm gonna give you all one more date, and hopefully by this time we'll have it resolved. We are on April the 16th. How many matters do we have on May 7th?
May 7th. You have 19 matters.
Okay, I'm going to adjourn this till May 7th. That's 3 weeks from now.
Your Honor, I have a surgery the day before, and I have a post-op appointment. Could we do it the following Friday? I have nothing
The
complicating my
14th?
schedule. The 14th,
No, we
yes.
can do it We could do it, May 21st. Because you have a lot of.
I can do it then too.
Okay, May 21st. May 21st at 9 o'clock.
Thank you, Your Honor.
All right, thank you. We'll see everybody on May 21st. Have a good day, Mr. Altamini.
Thank you.
You too, Your
Thank
Honor.
you.
All right, let me put a note in. Okay. Are the parties here on Hussein Syed? Okay, are the parties here on Franklin?
I'm here, Your Honor, but Mr. Nelson's case, Rick Nelson.
Nelson's not here. Okay, parties here on Wade?
That's Rena Mitchell.
Not here. We have a bunch of defendants and no attorneys. All right.
I'm still here, Your Honor. I'm just trying to find my client.
Okay. What time is your officer scheduled on Mr. Glenn's case?
I think he's here, Judge. Mr. Trooper Larry Cobb, are you here?
Yes, I'm here.
Yeah, he's here, Judge. Thank you. Hi.
Okay. Well, then we can begin that hearing. Yep, this is Cummings. Mhm. Thank you.
Calling case number 20004405, the people of the state of Michigan versus Aaron Cummings. This is scheduled for a pretrial and a motion hearing. Appearances for the record, please.
Good afternoon, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
William Glenn on behalf of Ms. Cummings, P 36794.
And Ms. Cummings, please state your name for the record.
Aaron Cummins.
Okay, I just want to be sure, Ms. Cummings, you aren't driving, are you?
I am not. I'm on break at work.
Okay, all right. Okay, this is the date for a hearing, evidentiary hearing. And so I believe that Madam Prosecutor has a witness. And
Yes.
unless anything further, we can begin the hearing.
Okay, great, Judge. Yeah, the people do have a witness. The people at this time would call Michigan State Police Trooper Larry Cobb via Zoom.
Yes,
Okay,
ma'am. This is Detective Trooper Larry Cobb, batch number
we have to-
879.
Okay, hold on, we have to swear you in.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
You can put your hand down.
And Ms. Cummings, please mute your phone. Okay,
May I
go
proceed,
ahead.
Judge?
Go ahead, yes, proceed,
Okay,
please.
thanks. Good afternoon, Detective Cobb.
Good afternoon, ma'am.
Okay, can you go ahead and please introduce yourself to the judge, telling her what you do for a living?
I'm a detective trooper with the Michigan State Police. I'm currently assigned to the fraud investigation section, and I'm a member of the bridge car enforcement team.
Okay, and how long have you worked as a Michigan State police officer?
6 years.
Okay, and did you work as a police officer before that?
No, ma'am.
Okay, so in total, your law enforcement experience is 6 years, correct?
Yes, ma'am.
Okay, all right, so I want to at this time bring you back to the date of September 17th, 2019. On that date, were you working in your capacity as a Michigan State police officer?
Yes, ma'am.
Okay. And back on that date of September 17th, 2019, what were you assigned to do as an officer?
I was assigned to be patrolling the city of Inkster as a part of the SCP, That was my group is Secure Cities Partnership. So we were strictly to help patrol the city of Inkster.
Okay. And while you were patrolling the city of Inkster, were you working alone or were you working with a partner?
I had a partner,
Okay. And who is that? Who was that?
Trooper Javon Strickland.
Okay. Can you spell that if you know how to spell his name?
Javon, last of Strickland, Strickland.
Okay. And so you and Officer Strickland were working patrol in the city of Inkster. How were you guys dressed?
We were in full uniform with our patches on each arm.
And does that uniform identify you as a Michigan State police officer?
Yes, ma'am.
Okay. And you were both dressed in a Michigan State police officer uniform?
Yes, ma'am.
Okay. And how were you and your partner traveling on that day? Was it on foot, in a car?
We were in a fully marked patrol vehicle.
Okay. Judge, and I'm sorry, is it my computer that's beeping like that?
I think it is.
Okay. I'm gonna try and log in on my phone. I apologize. Okay, I think it went away, so I'm gonna try. Hopefully it doesn't come up again, but if it does, I'll switch over. Okay, so you just said that you were in a, okay, I'm just gonna switch over, Judge.
Okay. Mr. Miller, is your client on?
He is as iPhone, Your Honor.
Okay. All right, since she's switching over, let's handle that matter, your matter right quick.
Yes, Your Honor. It sounded like she had something placed on her keyboard.
It's Hussein Saeed.
Judge, Prosecutor Andrea McCray, P number 83698. Apologies, I'm now appearing on my phone, and hopefully there won't be any technological interference anymore. Just let me know if I'm able. Sure.
Okay, hold on one second, Ms. McCray. We switched because Mr. Saeed is on, so we're gonna go ahead and do this calendar conference right quick.
Oh, okay, sure.
Okay, go ahead.
Okay. Calling case number 20005060, the people of the state of Michigan versus Hussein Said. This is scheduled for a calendar conference. Appearances for the record, please.
Good afternoon, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Good afternoon, J. Grant Miller, P58658, on behalf of Mr. Saad, who appears via Zoom.
State your name for the record, please.
Hussein Saad.
Okay, this is the date set for a calendar conference. The court has signed the pretrial conference sheet as well as the scheduling and the order of reciprocal discovery. Is there an offer by the people in this matter?
Judge, my understanding is that the defendant had been accepted into the drug court program, but that he did not want to go to the drug court program. And I didn't know, I asked for this hearing today after a worrisome email I received from brother counsel. And so I don't know if he wants to shed some light on what he told me. I think it's probably better if he does that.
Okay.
Your Honor, oddly in this case, when I first got the appointment, the people actually provided me the phone number of the victim. And he kept talking to me and wouldn't stop. The victim in this case is actually my client's father. And my client's father had some pretty unique ideas on how he would like this case to be handled, none of which I believe are proper nor legal, especially not at a state court level. as I believe my client was born in the US and his father wants him deported back to Lebanon where he can't use drugs. And I believe he may have tried to do that in the past. I believe my client would be a good candidate for drug court, but I believe my client might be under the impression his father's going to drop the charges and he's not going to go to prison. So I've asked my client to think long and hard about drug court or prison.
Okay, well, there isn't any representative on the call from drug court, so he must not be admitted into drug court. And I haven't received anything. Mr. Saeed's guidelines are only 0 to 9, which means he's not prisonable. He's only probationable, at the most jail. So that being the case, if he has not been accepted into drug court, then we need an offer from the prosecutor's office. So
Yes, Judge, the offer would be to plead guilty to attempt, uttering, and publishing, count 1. The sentence agreement would be 2 years probation, no restitution in this matter because the check wasn't cashed. So there's no restitution, but it would be 2 years probation.
okay, so count 1 has been dropped to an attempt, which means it goes from what, 14 years to 7?
I think it's
Or is it
5.
5?
I think 5.
Five?
Yes.
Okay, and people are up in 2 years probation, no
Correct.
restitution. Okay, so do you, Mr. Saeed, did you hear that offer from the people?
Yeah, I talked to whoever talked to me about the drug court or whatever. I took the information down. I was at work, so I wasn't available to talk to her, but I do have the information and I did forget to call, so that is my fault. Can I think on this or do I have to make a decision today?
No, you do not have to make a decision today. So are you telling me that you're not completely adverse to drug court?
No, I'm not. But I'd like at least, a couple of weeks for, just at least a couple
Okay,
weeks to
that's
think
fine.
on it.
That's fine. What I'm
Yeah.
going to do is give you all some dates. The exam was waived, so I doubt if there are any motions. But what I'm gonna give you right now is motions shall be time stamped and filed no later than May the 28th. Motions will be, timely file will be heard on June 4th. That's the same day as the final conference, June 4th. These documents with respect to the calendar conference and the order of reciprocal discovery will be emailed by the clerk to these individual parties. Additionally, I will give you a pretrial date to come back. So defense counsel, you need to contact drug court, make sure they can get in touch with the client, since it seems like he's not adverse to drug court, okay?
Yes, Your Honor.
All right, and I'm gonna set us to come back on May. I'm gonna set us to come back on May the 21st.
Okay.
And we'll see at that point, if you all are able to resolve this before May the 21st, then contact the court, we can put it on the docket. So May the 21st for a pretrial at 9 a.m.
Thank
Okay,
you.
thank you, Your Honor.
All right, thank you.
All right,
Please
bye.
contact drug court and see if you can work it out.
Thank you, Your Honor.
All right, this matter is concluded.
I'm sorry, Judge, for those reciprocal discovery orders, they can pull those on Odyssey, so we stopped emailing them. They can go on Odyssey and find it.
Okay, so you're gonna input it into,
Yeah, I'm
Oh, okay.
gonna scan it in.
okay.
Just FYI, sorry, I'm not ever able to pull up any orders from Odyssey. I can just get the preliminary exam transcript, and that's what I think defense counsel can only pull up too.
I actually have trouble pulling up transcripts off Odyssey. I can see that there's a document there, but going into the public access, we can't pull up orders.
Okay, so it'll be email. I know the only thing the court can even pull up is the transcripts and motions file. We can't even get, I'm sorry, preliminary exam transcripts. We can't even get transcripts from here. We have to order. Okay, so let's briefly, since we now have, we have Willis Neely on the line. Okay, then Wade. Ms. Mitchell, are you on the line?
Yes, Your Honor.
Okay, and, Mr. Nelson. Are you on
Good
the
afternoon,
line?
Judge.
Good afternoon, is your client here?
He should be. I'm ready to go.
Mr. Franklin, are you on the line?
Yep.
Okay, let's go ahead and do this in right quick. Yep, that's on.
Your Honor, could the clerk send me over another pre-sentence report for Wade?
I'll have, the day after the clerk calls this next case. Okay, go ahead. Yes, Jermaine Franklin. Okay.
Calling case number 20001979. The people of the state of Michigan versus Damian Franklin. This is scheduled for a sentencing. Appearances for the record, please.
Good afternoon, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Good afternoon to you and your staff, Judge. Ricky Nelson, P39317, on behalf of Mr. Franklin. Mr. Franklin, state your name.
Damian Franklin.
Hey, this is the date, time, and place of the sentencing this matter. Mr. Franklin, do you consent to be sentenced over Zoom?
Yes.
Okay, there was a plea agreement in this case that if Mr. Franklin pled guilty to controlled substance possession, narcotics, cocaine, less than 25 grams, which has a max of 4 years, that the people would enter into a plea agreement of 18 months probation and drug treatment, dismiss counts 2, and withdraw the notice to enhance the habitual fourth. And I'm showing that there's 2 days jail credit. Have the parties had an opportunity to review the pre-sentence investigation report?
Yes, I have, Your Honor.
Okay.
Yes.
Defense, any corrections, deletions, or additions to the body of the report?
No, Your Honor.
All right, and Madam Prosecutor, any corrections, deletions, or additions to the body of the report?
Yes, Judge, I do have a few. Number one, on the cover page, I believe he's been convicted of 4 felonies, not 5.
Okay.
The issue comes in when you go to under the, what is this, where they list.
Adult history?
Yes, Your Honor. If you look at the 7/23/2013 date, they're counting 2 delivery offenses, and on his lien, I only saw 1 controlled substance delivery of marijuana.
All right, I see he was charged with 2, the final charges, and he pleads. Okay, on the final charges, they're showing controlled substance delivery, manufacture, narcotics, cocaine less than 50 grams, and controlled substance delivery, manufacture marijuana.
So according to my lien, it's just the delivery of marijuana.
Okay, Mr. Franklin.
Yes.
In 2013, did you take a plea to marijuana and cocaine, or was it just marijuana?
I think it was just marijuana, Your Honor.
Okay, so in the front, it should be 4 felonies instead of 5, correct?
Yes.
Any objection, defense?
Obviously, no, Judge.
Right, I didn't think so. But... All right, anything else, Ms. McCray?
Yes, under evaluation and plan, under paragraph 2, it says 5 prior, and obviously it should be 4.
Okay, under evaluation and plan, hold on one second. under paragraph 2. One second. Evaluation and plan, paragraph 2. Okay, where it says 5, we're switching that to 4. All right, I'm gonna make that change in initial. Anything else?
No, Judge.
Okay, have the parties had an opportunity to review the sentence? I'm sorry, Mr. Franklin, did you have an opportunity to go over the pre-sentence investigation report with your attorney?
Yes.
All right, is everything in the report true and accurate now that we've changed your prior felonies from 5 to 4?
Yes.
Okay, have the parties that reviewed the sentencing guidelines?
Yeah.
Yes.
Yes.
Have their 0 to 11, is that correct?
Correct.
Judge, that is correct, although I do believe PRV 2 should be 20.
Okay, so currently they have PRV 2 as 5. And PRV 2 is, what is PRV 2?
PRV 2 is the lower severity prior felony convictions.
Okay, and he has 4, so it should be 20 instead of 5.
Correct, Your Honor.
Any objection from defense?
None.
Okay, so what does that make PRV level now, Ms. McCray?
It's still D. It just changes the total to 47, but it's still D.
Okay, any objection by defense?
None.
All right, OBs are showing as 0, is that correct?
That's correct.
Yes.
Does it change the guideline minimum range?
No, it does not, Your Honor.
Okay. All right, is there anything else with respect to the people?
At this time, the people would move to dismiss count 2 and move to withdraw the habitual 4th offense notice.
No
No
objection.
objection by defense? Okay.
No.
Anything else, Ms. McCray?
No, Judge, thank you.
All right, the court will dismiss count 2 and withdraw the notice to enhance habitual 4th. Defense counsel, is there anything further you would like to say on your client's behalf before I impose sentence?
No, Your Honor, not in light of the fact we have a sentence agreement. Thank you.
Okay, and Mr. Franklin, is there anything you'd like to say to the court before the court imposes sentence?
No, Your Honor.
The court will issue you pursuant to the sentence agreement, which is 18 months probation, drug treatment, dismissing count 2, withdrawing the notice to enhance habitual 4th. There's 2 days jail credit, is that correct?
Correct.
Counselors, 2 days jail credit, correct?
Yes.
Okay. It is, Mr. Franklin, you must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of alcohol testing directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. You must present proper identification at the time of testing. You must comply with the requirements of drug testing directed by the field agent, and you must not attempt to submit fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedure, and you must present proper identification at the time of testing. You must not use or possess any controlled substance or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must attend AA, NA, and/or CA meetings at the frequency required by the field agent. You must complete outpatient or residential substance abuse treatment when you are referred by the field agent. You must participate in an adult educational GED program. Well, Mr. Nelson, do you have your GED or a high school diploma? I'm sorry, Mr. Franklin?
No, I signed up for it last time, but I just need 2 credits.
Okay. That clearly will make you more marketable. You must complete a psychological evaluation when referred by the field agent. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week. Are you currently employed, Mr. Franklin?
No, not yet.
Okay. Unless engaged in an alternative program approved by the field agent. Mr. Franklin, I am going to give you the number to a program to see if they can help you get employment, okay?
Okay.
I want you to contact Detroit at Work. Tell them you are referred by Judge Baker for their
Okay,
help.
you say Detroit at Work?
Yes, that's what's at the top of the, I think it's Michigan Works is actually what it is. And the phone number is 313. 628.
628.
2228.
2228.
Correct. Repeat that back to me, Mr. Franklin.
313 628 2228.
Correct. All right, it's for Detroiters who are on probation or parole who need a job or job training, because I don't want to see you back here, Mr. Franklin, okay?
Okay, thank you.
I want to see you get to the next level, so. All right, and so I am requiring that you call that number, and I'm gonna put it in here in your pre-sentence report. Okay, judge requiring that you contact Michigan Works is what I believe it is.
Okay.
Okay, and once you do obtain a job, which I believe you will, you have to maintain employment of 30 hours per week unless engaged in an alternate program approved by the field agent. You must provide ongoing verification of employment or alternative programs to the field agent. You shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission from the field agent. You must pay $68 state costs. You must pay crime victims assessment in the amount of $130. Now, I understand you're not working right now, right?
Yeah, correct.
Okay, so your court costs are normally $1,300. Because you're not working, I'm going to waive those. And you normally have $400 attorney fees, and I'm gonna waive those, okay?
Thank you.
You're welcome. All right, it's my duty to advise you that you have a right to request leave to appeal from the Court of Appeals to appeal your plea and sentence. If you are unable to afford an attorney to prepare a post-conviction motion or perfect an appeal, this court will appoint an attorney for you at public expense and will provide that attorney with such portions of the transcript as that attorney may require to prepare the motions on appeal. You are further advised that if you wish to file an appeal or motion, the request for the appointment of an attorney must be made in writing and filed with the clerk of this court within 42 days of today's date. The clerk will email the advice of rights form to your attorney, who will forward it to you. Does your attorney have permission to initial the form on your behalf and acknowledge your receipt of the form, Mr. Franklin?
Yes.
Okay, and that's the form you must file with the clerk of this court within 42 days of today's date, but only if you wish to appeal and need to have counsel appointed for you. If you don't wish to appeal, you do not need to turn the form in. All right, you have to contact probation department today. I'm going to give you their phone number.
Okay.
You ready?
Yeah.
It's 313.
Okay.
456. 4600.
Okay.
All right, before you hang up, Miss Schoen. Miss Schoen?
Yes, Judge.
I added to the report for Mr. Franklin to contact Michigan Works. Do we need to then send a copy of this back to the probation department so they will know that?
As long as it's written, it has to be written on the referral or on the agreement.
On the
Probation order.
probation order, so you'll just put it in there.
Yes.
Okay, all right, so it will be written on the probation order. All right, thank you.
You're
All
welcome.
right.
Thank you, Judge.
Is there anything further from the parties?
No, Judge.
Thank you.
All right, thank you, Mr. Franklin. Good luck to you.
Okay, thank you.
Thank you, Judge, staff, prosecutor. Have a good weekend. See you, Damon.
You too.
All right, see you. All right.
All right, okay, we're going to resume the hearing on, Cummings. All right, go ahead, man. Recalling case number 2000440501 on Aaron Cummings. Appearances again, please.
Good afternoon, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
William Glenn on behalf of Ms. Cummings, P36794.
Okay, and Mr. Cobbs, you were put under oath. You are still under oath, and you may continue, Madam Prosecutor.
Thank you, Judge. Okay, Detective Cobbs, I believe we left off at the point where you said that you were working patrol in the city of Inkster with your partner, Trooper Javon Strickland. Is that correct?
Yes, ma'am.
Okay. And when you and your partner were working patrol on September 17, 2019, did your duties bring you to Inkster Road near Jeffrey Lane?
Yes, ma'am.
Okay, and is that location in the city of Inkster?
Yes, ma'am.
Is it in the county of Wayne?
Yes, ma'am.
Okay. So what brought you to that location?
Well, Inkster is about 5 miles wide, so we kind of just patrol throughout the city to see if we can be doing the proactive patrol. So I just happened to be in that area at that time.
Okay. And when you were on proactive patrol in that area, did you come into contact with a black Ford SUV?
Yes, ma'am.
Okay. And what led you to come into contact with that black Ford SUV?
Well, we're both making a left-hand turn to go eastbound on actually it's Michigan, and I just so happened to get behind that vehicle.
Okay. And when you were behind that vehicle, did you observe anything after being behind it?
Well, we were both stopped at the red light in the turning lane, and the light turned green, and the vehicle turned, and instead of turning into the left lane, they went into the middle lane.
Okay. And is that a traffic violation?
Yes, ma'am.
Okay. Is that a ticketable offense?
I'm just sorry, briefly. What was you said the vehicle was where?
It was in the left. Well, we're in a turning lane to turn to go back eastbound on Michigan. So you had to go through the U-shaped turn.
Okay, and you said that the defendant's car was in the middle lane?
No, the defendant turned into the middle lane to go eastbound on Michigan.
Oh, okay, okay. I got you.
Okay. And just to follow up on that, the defendant turned into the middle lane, but the traffic laws would prescribe that she needs to use
the left lane.
The left lane. Okay. And is that also known as improper lane use?
Yes, ma'am.
Okay. And is that a ticketable offense?
Yes, ma'am.
Okay. And once you saw the defendant use an improper lane, what did you do in response?
Well, I got in behind the vehicle and I turned on my lights and my camera activated.
Okay. Now, once you turned on your lights, did the vehicle stop?
Yes, ma'am.
Okay. And so when the vehicle stopped and pulled over, what did you do?
I approached the driver's side of the vehicle and made contact with the driver of the vehicle.
Okay. And who was the driver of the vehicle?
Miss Erin Cummings.
Okay. Do you see Erin Cummings today in Zoom court?
Well, before her camera went off, yes, I do.
Okay. Can you identify her by an article of clothing and anything unique, perhaps that's in her Zoom view, if you see her?
She has on a black sweatshirt with, I guess that's pink trim, and she has on a black pair of glasses.
Judge, let the record reflect that Detective Larry Cobb has identified the defendant by glasses, and I think he said her shirt as well.
And record so reflect.
Thank you. So, Detective, you said that you approached the driver's side of the vehicle, and that was Aaron Cummings, correct?
Yes, ma'am.
Okay. Now, what did you do or say when you first approached the vehicle?
So I identified myself and let her know why I was stopping her for the improper lane use violation. And I asked for her driver's license.
Okay. And so you identified yourself and then you asked her for her driver's license. What did she do in response?
She gave me her driver's license.
Okay. Go ahead.
I usually, because through my training experience, that's a high crime, high drug activity area. I always ask, is there
Objection, Your Honor, this isn't relevant.
How is that not relevant to the traffic stop?
Well,
high crime and making an illegal turn are two entirely different things here.
Yeah, but it goes through the totality of the circumstances.
Hold on one second. Hold on, both counselors. I didn't hear if there was another question. The only question I heard was you asked for her license, and she asked, the Madam Prosecutor asked, was the license provided? And he said yes. There wasn't even another question on the floor. And then I think he just started talking about the area. So we're going to strike that at this point. We need to ask questions and then just answer the questions asked.
Okay. Detective Cobb, can you describe the area that you were patrolling?
I was patrolling Eastern Michigan. I've been patrolling over there for a while. I was near a gas station on Michigan near Jeffrey Lane.
Do you know anything about the area as it pertains to crimes?
There is a high crime area and a high drug activity area over in Inkster.
Okay. And you know that based off of your training and experience?
Yes, ma'am.
Okay. And when you were patrolling on September 17th, 2019, was that something that you had in the back of your mind as you were patrolling?
Yes, ma'am.
Okay. So taking you back to when you were actually speaking to the driver, did she immediately give you her driver's license?
Yes, sir.
Okay. And so what did you do once you received her driver's license?
I was just having general conversation with her. I was asking her where was she headed and where was she coming from.
Okay. And was she able to provide you answers to those questions?
Yes, ma'am.
Okay. And so what did you do next?
I always, on just about every traffic stop, I always ask, is there anything in the vehicle that I need to know about? And I asked her that question.
Okay. How did she respond when you asked her if there was anything in the vehicle you needed to be aware
of? If I recall, I don't think she said there were anything in the car that I need to be aware of. And I asked, she started to give me some nervousness. That's why I asked her to search the vehicle.
Okay. So I want to just dissect that a little bit. Okay. So you asked her if there was anything in the vehicle that you needed to be aware of, correct?
Yes.
Okay. The response that she gave you was no, correct?
Yes.
Okay. However, at that point, was she exhibiting any behaviors that drew you, that made you concerned?
She just seemed nervous to me. Okay.
And describe what you mean by that. Can you give me some physical attributes or maybe some more descriptions about what you mean by she seemed nervous?
Well, she was looking around instead of looking directly at me. She was looking around inside the vehicle.
Okay, so would it be fair to say that she wasn't maintaining eye contact with you?
Objection, Your Honor. The prosecutor's trying to lead this witness. You can testify to what she was saying and doing without her leading.
Objection is sustained. No leading question.
Okay.
You can't suggest the answer in it. Just ask him what was she doing, not was she not maintaining eye contact. Let him explain what it was she wasn't doing.
Okay, can you describe the eye movements that she had?
She was not looking at me. She was just looking around, looking out the front windshield, looking out from the sides of the vehicle. She wasn't really paying attention to me.
Okay, and based off your training and experience being in a high crime area, and a driver who is exhibiting that observation, does that mean anything to you?
They may be just nervous because there may be something more going on, or they may just be nervous
I'm
because
going
I'm
to
a
object
police
that this
officer.
is all speculation.
I'm gonna overrule it. He can give as a layperson his opinion in his experience. He's been an officer for 6 years. He could say that's what he thought, but let's move on. Go ahead.
Okay, Judge. Okay, and so after you saw her exhibiting behavior with her eyes, what did you do in response?
I asked her, would I be able to take a look inside the vehicle?
Okay, and when you asked her if you could take a look inside the vehicle, what did she say?
She gave me verbal consent to go on to look inside her vehicle.
Okay, did she say yes or no?
She said yes.
Okay, so let me ask you, from the time that you stopped the vehicle and you first approached the vehicle to the time that you asked to search the car, how long of a time period was that?
I do not recall.
Okay. All right. So after she had said yes, that you could search the vehicle, was she inside the vehicle at that point?
Yes.
Okay. Did she at any point tell you that you couldn't search a specific area of the vehicle?
No, ma'am.
Okay. Did you tell her that she was going to be under arrest if she didn't agree for you to search the vehicle?
No, ma'am.
Okay. Did you make any other promises or threats to her?
No, ma'am.
Okay. So when she said yes, then what happened?
My partner was speaking with passengers on his end, and he let him know that he had some warrants. So he was placed in handcuffs, and I just asked Ms. Cummins to exit the vehicle.
Okay. So your partner placed the passenger in handcuffs, and Ms. Cummings exited the vehicle. Was she put in handcuffs at that point?
No, ma'am.
Okay. Where did she go to stand, or what did she do?
I always have people, I had her stand in front of my patrol car, right in the front bumper in front of the camera.
Okay. So while she was standing in front of your bumper, what did you do?
I had my partner was watching Ms. Cummings and her passenger, and I began searching the vehicle.
Okay. Where did you start when you began to search the vehicle?
On driver's side.
Okay. Did you find anything on the driver's side?
I didn't find anything immediately in the driver's side. I actually found what was located in the vehicle inside the center console.
Okay. And what did you find inside the center console?
A plastic baggie with 6 pills in it. It was like 6 pills.
Okay. Now, was there a prescription bottle nearby?
No, ma'am.
Okay. So it was just loose pills inside of a clear plastic baggie?
Yes, ma'am.
Okay. Did Ms. Cummings ever provide you with a valid prescription?
No, ma'am.
Okay. Was there ever a prescription in the car?
No, ma'am.
Okay. Was there ever a prescription bottle found in the car?
No, ma'am.
Okay. So you said there was about 6 loose pills in a plastic baggie, correct?
Yes, ma'am.
Okay. What did you believe, based off your training experience, did you form an opinion as to what you might have thought those pills were?
I did not know what they were, so I asked her what they were.
Okay. And did she provide you with a response?
Yes, ma'am.
What did she tell you?
She said they were called tramadol.
Okay.
So I went back to my, never mind. Go ahead.
No, go ahead. So what did you do after she told you they were tramadol?
I went to my patrol vehicle to try to pull up a website to figure out what kind of pill it is, and we use a website called drugs.com.
Okay. And what did you find out?
That it was a controlled substance.
Okay. And was it tramadol?
Yes.
Okay. And what did you do with that tramadol once you recovered it?
I went back to her to ask her if she had a prescription for it. We had a conversation prior to her, and I asked her, did she have a prescription for it? And she said, if I don't, it's been a while, so I can't remember whether she said if she had a prescription or not. I'm not sure.
Okay, but she never provided you with a valid prescription?
No, ma'am.
And you never found a valid prescription in your investigation or in the car?
No, ma'am.
Okay. Now, did you put those pills onto evidence?
Yes.
Okay. And did you take them back to headquarters?
Yes.
Okay. And did you eventually send them off to be tested?
Yes, ma'am.
Okay. Judge, I have no further questions at this time.
Yes, Detective, you stated that you stopped Miss Cummings for a improper turn. Is that correct?
Yes, sir.
Now, you were on routine patrol on September the 17th, 2019. Is that right?
Yes, sir.
And that was at what time in the evening?
It was about 20 minutes to midnight.
Okay. And you stated that you saw Miss Cummings in a black SUV. Is that right?
Yes, sir.
And you stated that she made a wide turn?
Yes, sir.
Now, that's a civil infraction. Is that correct?
Yes, sir.
When you stopped the car, you asked to see her license, proof of insurance, and car registration. Is that correct?
I think that's what I know. I asked her for a driver's license. I'm not sure if I asked her for a registration insurance.
Right. And she provided you the documents that she requested. Is that correct?
Yes, sir.
Now, you stated that when she made the wide turn, you informed her of that. Is that correct?
Yes, sir.
That was a civil infraction.
Yes, sir.
All right. What is the ticket number of the civil infraction for Ms. Cummings making the wide turn? What is the ticket number?
The ticket number?
Yes.
I'm unsure.
For the civil infraction. You stopped her for a civil infraction making a wide turn. Give me the ticket number.
Objection, Judge, to argumentative. He can ask it. He doesn't have to have a condescending tone.
Okay, I'll say it pleasantly. What was the ticket number for Miss Cummings' civil infraction?
There was no ticket number.
Okay, so you never gave her a ticket for that, did you?
No, sir.
All right. Now, you stated that when you stopped her, you asked her, was there anything you should know about in the car? Is that correct?
Yes, sir.
Now, besides Miss Cummings looking away or appearing nervous, what else did she do to make you believe that there was something illegal contraband inside the car?
Judge, I'm going to object. I don't think his testimony was that he believed there was something illegal in the car at that point. I think his testimony was that she was nervous, and he always asked that question.
Well, he's saying that this was.
Hold on. The court has heard the testimony, so I've heard the testimony. Go ahead.
Okay. All right. Now, you stated that you wanted to search the car. Is that correct?
Yes, sir.
Now, isn't it true that when you searched the car, the passenger, a young man by the name of Jason Graham, was placed in handcuffs? Is that correct?
Yes, sir.
Now, when you asked to search the car, did you tell Miss Cummings or Mr. Graham that they would be handcuffed while you searched the car?
I did not tell Miss Cummings that she was going to be handcuffed. No.
All right. Now, did you tell Miss Cummings or Mr. Graham that they were free to leave?
No, I didn't tell either one of that.
Now, you stated that Mr. Graham had traffic warrants. Is that correct?
Yes, sir.
Isn't it true that you informed Mr. Graham that he had traffic warrants after you had placed Ms. Cummings under arrest?
I don't recall.
Did you review the dash cam and body cam video in this case?
No, sir.
Okay, so you haven't seen it?
Not since the night of the traffic stop. No, sir.
All right. Now, you stated that you found these pills in the center console.
Yes,
Is
sir.
that right?
Yes.
All
sir.
right. Now, when you stopped this car, were either one of these individuals in the car smoking marijuana?
I do not recall.
Were any of these two people in the car drinking alcohol?
I do not recall.
Did any of these people in the car act aggressively towards you as though they had a weapon or were trying to reach for a weapon?
No, sir.
All right. So this traffic stop for a civil infraction, how long does that normally take for you to write a ticket?
I don't have a set time. It's not something that I keep track of or how long my traffic stop is.
Isn't it true that this traffic stop took over 20 minutes?
I'm not sure. I didn't see the duration of the
you saw the
stop.
dash cam, and body cam. If it went 20 minutes, you wouldn't dispute that, would you?
He said he didn't see it.
I didn't see it, so I wouldn't be able to dispute that.
All right. Now, you stated that you saw this car on Michigan Avenue near, what was it, Jeffrey Lane?
Yes, sir.
Now, isn't it true that you were behind this car, following it?
I was not following the car. I just happened to be behind the car.
And you weren't on Michigan Avenue. You were on Jeffrey Lane, which is an apartment complex?
No, sir. I was
or
on
a
Michigan.
motel? A motel?
I was on Michigan.
Okay. But it's your testimony that you were not following this car?
Yes, sir.
All right. And who was your partner again?
Trooper Javon Strickland.
All right. Now, you stated that, he stated on the dash cam that Mr. Graham
Judge,
had.
I'm not object to hearsay.
Okay, all right. Now, you stated that Mr. Graham had warrants for his arrest. Is that correct?
Yes, sir.
Did you arrest him for his warrants?
No, sir.
All right. Nothing else, Your Honor.
Okay,
Judge,
I have a question. The passenger had warrants, but he was not arrested for the warrants?
No, Your Honor.
Okay. All right, Madam Prosecutor, any?
Yeah, just one question on recross. To be clear, was Miss Cummings ever in handcuffs when you were searching the vehicle?
I do not recall.
Okay.
Okay. I have one last question. Which was, when you asked Miss Cummings if there was anything in the car, I just want to be clear that you should know about, her response to you was no. Is that correct?
Yes, Your Honor.
Okay. And then after she told you no, well, when she told you no, did you have her license at that time?
Yes.
So you already had a license when she told you no, correct?
Yes, Your Honor.
All right. And then after she told you no, based on her eye movements, you asked her to search the car. Is that correct?
Yes, Your Honor.
Okay, the court doesn't have anything further.
I don't have anything further, Judge.
Nothing else.
Okay. Argument?
I'll defer to Brother Counsel. He brought this motion.
Well, Your Honor, Your Honor has seen the video in this case. Even if this was a civil infraction, you ask for the license, car registration, proof of insurance, and if there are no problems with that, you just write the ticket if you're going to do that. Now, if the officers or the police smelled marijuana or they saw what they thought was a weapon, well, then that's different. But when you look at this video, which is about 20 minutes long, you clearly see that this was just a random stop and they wanted to search. And when you look at the way Ms. Cummings and Mr. Graham were treated by the police, they were obviously not free to leave. I don't understand how someone can give you permission to search a car and then you place one of them in handcuffs and say that this isn't a stop or an arrest. It clearly is. Now, Your Honor, if they were going to write a ticket, I asked the officer here, the detective here, a simple question. What was the ticket number? He never wrote a ticket because that was never his intent when he stopped the car. If he wanted to stop the car and issue a ticket, he would have done that. He checked the license, he checked the registration, he checked the insurance. If she made a bad turn or improper turn, or she was speeding or whatever, he should have written a ticket for that. So if you take what he's saying to this court right now, that if this was an improper turn, this argument is completely bogus if he didn't write a ticket. So I would say that this is an illegal search and whatever was found should be suppressed.
Okay, also Trooper Cobb, let me ask this for each party. Both of you, we are done with Trooper Cobb, is that correct?
Yes,
Yes,
sir.
Your Honor.
All right, Mr. Cobb, Trooper Cobb, you are available to leave at this point.
Thank you, ma'am.
All right, have a good day.
You too.
All right. All right, go ahead, Ms. McCray.
Yes, Your Honor. So, Miss Detective Cobb testified today that he had not seen the dash camera footage. I know Your Honor has seen the dash camera footage. My understanding from the dash camera footage is that the time period between the officers coming to the driver's side of the vehicle and passenger side of the vehicle and asking to search the vehicle was about 1.5 minutes. And my understanding and recollection from the dash camera footage is that when the officer asked if there was anything in the car and whether he could search the vehicle, the defendant had not provided the license yet to the detective. That was my understanding of the video. I know he testified differently today. He wasn't able to view the dash camera footage. So I just think it is what it is at this point. And we would argue that there was, police don't have to write a ticket when they see a traffic infraction. So that is what the people have.
Okay, well, the court having heard the testimony of Trooper, let me make sure I have the name correct. Trooper Cobb, I believe it is, who testified on direct. He's been a trooper for 6 years with Michigan State Police, he was working on the date in question. He was patrolling the city of Inkster with a partner, Trooper Javon Strickland, full uniform. When Madam Prosecutor asked him, what he was doing, he just indicated patrolling the city of Inkster. He didn't mention in the beginning anything about Inkster being a high crime area until later. I don't know if that's supposed to mean the entire city of Inkster is a high crime area, but whatever. So he's with his partner, they're in full uniform, and the defendant does make an improper turn, which is a ticketable offense. And up to that point, the trooper, they stop the car, they turn the lights on, they're in a fully marked patrol car, they're in full uniform, and they do, per Mr. Cobb's testimony, they do tell the driver what the reason for the stop is. So at that point, he has followed the rules, and it's a Ford SUV black. He indicated that the defendant turned from the middle lane, but should have been turning from the left lane. So it was, instead of turning from the left lane, turn from the middle. So it's a ticketable offense, improper lane turn. He then said he approached the driver's side. There were two people in the vehicle. Miss Cummings was the driver. There was another individual on the passenger side. He identified himself, told her why she was being stopped, asked for a license, which she provided immediately based on his testimony. Then he starts to try to describe the area, saying it was near a gas station. And then he says it's high crime area, although he hadn't been asked that question at that point. And he says he then just answered some general questions, which she answered. He asked if there was anything in the vehicle that he should know about, of which she responded no. Now, at this point, Chupacabra then says because her eyes are looking around inside the vehicle instead of at him, he believes somehow that means something. What, I don't know. I guess, well, he said he believes she looked nervous. And he asked at that point if he could look inside the vehicle. He says that she says yes. The court has reviewed the video. I actually believe she said okay, is what I think she said. How long was he at the vehicle before he asked to search the vehicle? He doesn't remember. He did testify that there was no threat to make her, didn't threaten her with the arrest, but he also didn't tell her that she was free to leave. The partner was with the passenger, and the passenger told the partner he had warrant and was handcuffed. But the interesting thing is he wasn't arrested. He had warrant. Asked the defendant anyway. The trooper asked the defendant to get out the car, and he began searching the vehicle. He didn't find anything on the driver's side, but he did find a plastic bag with pills in the center console. These pills didn't have a prescription bottle, and he didn't know what the pills were. So he asked the defendant, and the defendant did say that they were her pills, and the court did watch the video. She told him that she had been on these pills since 2016. She had a prescription since 2016. Tramadol is what I believe it is. The trooper went to check, found out that tramadol is a controlled substance. But true enough, they were not in the proper pill bottle as they should have been. She did not provide the trooper with any prescription. And he can't remember what was said, but he can't remember. He couldn't remember what it was she told him, but the court watched the video. She did tell him that she had a prescription for them at one point. And he said he couldn't remember what she said, but he knew she didn't provide any documentation of a valid prescription, and he didn't have a pill bottle. On cross, the defense asked him about the infraction and basically making a wide turn. He indicated on cross, he told defense that she provided her license. Cross then asked about the ticket number, and what eventually came out on cross is he never even wrote the defendant a ticket for the civil infraction. Defense asked him again when he asked the defendant if she could search the car. She did say yes. He also asked him again when she said to you, when you asked her if anything was in the car that you needed to know about, she said no. And he still asked her to search the car. He did said he wasn't sure if he handcuffed Miss Cummings. I'm not sure if Miss Cummings was handcuffed. I don't believe I remember seeing Miss Cummings handcuffed, but she was asked to step out of the car. Clearly, she couldn't leave because she was moved to the police car and her vehicle was being searched, so she couldn't leave. He also never told her she was free to leave. He was also asked by the defense whether anybody appeared to be drinking alcohol, and the answer was no, or he didn't recall. I'm sorry, he didn't recall. If anybody was smoking marijuana, he didn't recall that. Asked whether he thought even a weapon might be in a car, which I guess would go to whether he'd be fearing for his life, so he would ask them to step out the car. He said no to that, even though this was a high crime area, and he's not sure how long the stop took. The car was on Michigan Avenue near Jeffrey Lane, I believe it is. The passenger had warrants and wasn't arrested. I also wrote down. On redirect, I think Madam Prosecutor brought out that Miss Cummings, she doesn't believe Miss Cummings was handcuffed during this incident at all. The court then asked whether after the trooper asked for Miss Cummings' license, did he have the license when he then asked her if there was anything in the car she should know about, and or whether that was beforehand. I'm not sure what he said on that one, but it was what was clear from the testimony is that he said he already had the license, and then she told him no, that there was nothing in the car. So instead of him just writing the ticket based on her eye movement, which I guess he thought made her seem nervous, he then had her get out, search the car, and finds these pills. So, case of People versus Bloxon, BLOXs and X-ray, SON 205, Mich. App 236. Under 242, indeed, even when officers have no basis, when officers have no basis for suspecting a particular individual, they may generally ask questions of that individual as long as they do not convey a message that the compliance with their request is required. Now, I guess my question is, it's based on what happened in this situation, in that the defendant was asked to step out the car so soon from the time that the trooper approached the vehicle. I don't believe that she would have thought she was free to leave. In addition, the passenger was handcuffed, so I'm sure he wouldn't have thought he was free to leave. So the issues here are whether the first issue under case law is whether there was a seizure. There was an arrest, but there is a seizure, and if there's a seizure, then the Fourth Amendment rights are triggered. The court believes that there was a seizure. I don't believe that these individuals felt that they were able to leave. I think maybe prior to being asked to be stepped out of the car, they might have thought that they could leave, but they definitely wouldn't have thought they would be able to leave once they were asked to step out of the car. And then the second issue is, was it reasonable? Was the seizure reasonable based on some reasonable suspicion supported by articulable facts that criminal activity might be afoot? That's the second issue. Once the court determines that there was a seizure, which would support searching the vehicle. And I don't find that to be the case. The officer testified her eye movements made him think that she was nervous. I'm not exactly sure how that translates into some criminal activity might be afoot. I'm not sure what the criminal activity would be. So since she looked that way, possibly there's something in this car that maybe is making her nervous. Anything. Is drugs, alcohol, marijuana, a gun? In the court's opinion, there was no reason. There was no reasonable suspicion based on the record of the testimony of the officer that would lead the court to believe that there was a reason for these individuals to be taken out of the car, or for the defendant to be taken out of the car, and for the car to be searched. Not just by her eye movement and the fact that she supposedly looked nervous. As I've indicated numerous times, a lot of people look nervous when they're pulled over by the police. So that being the case, the court is going to suppress the evidence. It was an illegal search.
Thank you, Your
Judge,
Honor.
if I may, the people's argument would be that the basis for the search was consent, which is of course a exception to the Fourth Amendment's requirement of warrant, and that she gave consent, and that also based on the case you cited, the Bloxon case, that police officers can ask other questions so long as it doesn't unreasonably prolong the stop. I don't think it did. It was within 1 minute. And so I think just the people's argument is that the eye movements is not the basis for the search. The consent is the basis for the search. So that's just what the people would say on the record.
And the court's response would be to that from that same case. The detectives in this case did not threaten the defendant by displaying a gun. However, unlike Boxer, the detective failed to advise the defendant that he had the right to refuse consent. The detective asked to look in the defendant's bag, and the defendant denied the request. Now, in this particular case, she gave it, but the case law is, I don't believe he indicated to her that she had a right to refuse the request to search the vehicle. And so
Judge, I don't think that's
the
law.
issue that the court has is that he did not let her know that she did not have to basically acquiesce to his request to search the vehicle. She didn't have to. She was not told that. The police asked her that, he did not say to her, but you don't have to acquiesce to this consent. He's asking her, but he's in the position of authority. And I don't believe she thought she had the ability to refuse. There are some drivers who say, no, why do you want to search my car? But in this particular case, he didn't tell her that she had the right to refuse him to search that vehicle. He didn't tell her that.
Judge, I don't want to interrupt you, Judge, so sorry.
Go ahead.
I just don't know of any law that requires police to tell a suspect that they don't have to consent.
There is in case law where it is indicated that the police should let individuals know whether they have their right. In this particular case, they talk about different cases, and one of the particular one is they asked this individual whether they could search him. I believe they were at the bus station, and he asked, do you have a warrant? And they told him no. And later on, he tried to move to suppress the evidence. The court said, well, he gave consent. What they said is the fact that he actually asked the officer whether they had a warrant was enough knowledge for him to realize he didn't have to consent to that search. And once they said no, if he had said no, you cannot search, then they would not have been able to. There is case law, and it is in the cases, both that case and I also read People versus Michigan, 2000 Westlaw 335-21026, where officers should alert individuals if they do not have a search warrant or really no right to search, that they do not have to consent to the search. And Ms. Cummings may not have known she did not have to consent to the search. So just because the fact that she said, okay, she's talking to a police officer. I'm sure Ms. Cummings probably thought she couldn't say no. So, but I don't understand, even going back before that, Ms. McCray, she gave consent, but why ask to search in the first place? It's a civil infraction. Why are you asking to search the vehicle? What the court has indicated is that there was no reasonable suspicion. It did not rise to the level of searching the car in the first place. They are seized. That's the first step that the court has to go through. And next, it is, was there some reasonable suspicion for this officer to believe that there was some criminal activity going on here? If he smelled marijuana when the car window rolled down, fine. If he saw something protruding from under the seat, fine. If he saw what looked like alcohol in the middle of the console, maybe it wasn't, fine. Because her eyes are diverting back and forth and she looks nervous, that is his reason for searching this vehicle? The court is saying he should never have asked to search the vehicle. He should have written her a ticket. and moved on. So before you even get to the consent, Ms. McCray, the court is saying, why ask her to search the vehicle? You've not articulated any reason why that was necessary. So that is the court's ruling. If I'm wrong, the Court of Appeals will, if it goes to the Court of Appeals, will let me know and it'll come back. And I guess I'll learn something. And that's the way I always see it.
Understood,
Okay.
Judge.
All right. This matter's concluded.
Thank you, Your Honor.
Have a good day, everyone.
Thank you.
Miss-
I don't know if it was formally dismissed though, because I know you suppressed the evidence, but
Oh,
I
I'm
think we
sorry.
need
I suppressed the evidence. Is there a motion?
I will move to dismiss, Your Honor.
All right. Based on the fact that the evidence has been suppressed, the court would dismiss the case.
Thank you.
You're welcome. All righty, where are we now? Willis Neely.
I'm ready on that.
The people are ready.
All right, what are we doing on Willis Neely? Is this the sentencing?
No, Your Honor.
Oh, it's the, I'm sorry.
When the court's ready.
You can call it.
Calling case number 21001103, the people of the state of Michigan versus Jamie Wills Neely. This is scheduled for a calendar conference. Appearances for the record, please.
Dwayne, good afternoon, Your Honor. Dwayne Brown on behalf of the people.
Good afternoon, Your Honor. Neighborhood Defender Service by Elizabeth Young on behalf of Mr. Jamie Wills Neely, P76842.
Good afternoon to everyone. All
Good
right.
afternoon.
This, Mr. Neely, state your name for the record.
Jamie Wills hyphen Neely.
All right, good afternoon, Mr. Wills Neely.
Good afternoon.
This is a calendar conference. The last time we were here, I believe the plea offer that was placed on the record was to plead to counts 1 and 2, dismiss count 3, guideline sentence, and is this, what do I have felonious assault and 2 years felony firearm. Oh, okay, as charged. As charged, there's a felony firearm, 2 years, and felonious assault as charged 0 to 6, I believe, is the guideline. Is this still the same plea offer?
Well, what has happened since we were last before the court, Ms. Young has submitted a gun board letter, and unfortunately, we don't have the decision as yet.
Okay.
People would be respectfully asking if the court could put it over a couple of weeks so we can get a decision, because we could get a better offer at that point.
Okay. All right, let me write a note in here. Waiting on a decision by the gun board.
How much time do you need?
How much time do you all need? When was the letter turned in?
I got the letter promptly last week, I believe Tuesday or Wednesday, I'm not sure.
So that
On the
means they
7th.
should- On the 7th?
Yes.
So that means they probably met on it this past week, the 14th.
No, they did not. Unfortunately, they did not, Your Honor.
Oh, they did not?
No,
Okay, so they may meet on it on the 21st.
that is correct.
So let's go the week after that.
You said May.
No, we're in April.
Oh, we're in April.
How many matters are April the 30th?
You have 18 matters. Are you in court on the 29th?
And Your Honor, I hear the court talking about the 30th. I'm going to be out of town from the 25th through the 30th.
From the 25th to the 30th? Okay,
Yes.
then we're gonna go into May. How many matters are on May 7th?
19 matters.
And how many on May 5th?
May 5th, you have 14 matters.
May 5th?
That works for the defense.
That's fine with the people.
Okay, May 5th at 9 o'clock.
Sounds good. Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
Everyone have a nice weekend.
You too.
Thank you.
Are we ready on Christopher Wade?
Ready, Your Honor.
Ready.
I have the PSI. I don't have the file. No. You don't have a file on it? Hold on. Okay, I have the PSI. We just don't have the file, but we can move on with the PSI. Oh, okay.
Calling case number 19003120, the people of the state of Michigan versus Christopher Wade. This is scheduled for a violation hearing. Also, case number 20001633. This is scheduled for sentencing. Appearances for the record, please.
Good afternoon, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Good afternoon, may it please this most honorable court, Raina Mitchell appearing on behalf of Mr. Christopher Wade. Mr. Wade, could you unmute and state your name for the record?
Christopher Wade.
And Mr. Wade, do you consent to having this hearing on Zoom?
Yes.
Your Honor,
Okay. Hold on one second. This is the date, time, and place set for the sentencing in this case. And there was a plea agreement to possession of burglar's tool, which is a 10-year max. Have the parties had an opportunity to review the pre-sentence report?
Yes, Your Honor.
Okay, as to the body, are there any corrections, deletions, or additions from defense?
Yes, Your Honor. In the address portion listed for the family members, it has one address listed for all of his children. That is not accurate. That's actually the grandmother's residence of his first child's mother. So I'm not even sure why he gave that address, Your Honor.
Okay, where are we on, under what section?
Hold on, let me get to it.
Oh,
It's
are
the
we
section,
under- Oh, go ahead.
the section with the family members and the addresses. Go to the page for you. Hold on one second.
Okay, is that under, it looks like it's page 5, where you see marriage, and then Liana Denise Wade, age 7, at 77, well, the address on Rosemont?
Yes, Your Honor.
Okay, so what you're saying to me is what? Who does not live on the Rosemont address?
None of those individuals live at that residence, Your Honor. That's the grandmother of one of the children.
Okay, so none of the people listed here live at this residence?
That's correct.
All right, do we have an address for these individuals?
Mr. Wade? Your Honor, they're minors, so I'm not sure if you really need that information because they're his children.
Yo, all 4 of my children were staying there. We all were staying there once upon a time, but they have moved, and no, I have no address for them. But I surely could get the address where she at, because she just moved.
Okay, so at the time the report was done, this address was correct?
Yes, it
All
was.
right.
Nothing further, Your Honor. No other
I'll just leave
additions,
that there.
deletions, or corrections. Okay.
Okay. People, any deletions, corrections, or additions?
Yes, Judge, on the cover page, the plea agreement was 3 years probation, the first year in Wayne County Jail.
Is that what the plea agreement was, defense? Are you?
Yes, Your Honor.
agreement?
Yes, Your Honor.
I don't know why that isn't on here. 3 years probation with What is it?
The
First
first,
year.
First year in the Wayne County Jail
Yes,
Yes.
Your Honor.
and dismiss count 2?
yes. And withdraw the habitual notice, third offense notice.
Okay, the court has written next to plea agreement. The only thing that's written here is dismissal of count 2. The court has written 3 years probation with the first year in the Wayne County Jail and withdraw the habitual third offense notice. Is that correct?
Yes.
Okay, I have initial next to that. Anything else, Madam Prosecutor?
Yes, when you go to Department of Corrections recommendations, so it should be on the back of the cover page. The period says 2 years probation. Obviously, the plea agreement was 3 years probation the first year in Wayne County Jail.
Okay. I'm making that change now. Okay, so I've crossed out the 2, first year Wayne County Jail. Are the 2 days jail credit correct?
Yes, Your Honor.
Okay. Anything else, Madam Prosecutor?
Yes, number 8 should be crossed out. There is a victim in this case, but there is no restitution.
Well, they don't have an amount here anyway.
Yeah,
I'll write on here, no restitution. Next to it, any objection by the defense?
No objections, Your Honor.
All right, everything else? Anything else, Madam Prosecutor?
No, Judge, thank you.
Mr. Wade, did you have an opportunity to review your pre-sentence report with your attorney?
Yes.
Is everything stated in the report true and accurate?
Yes.
All right, and Mr. Wade, did you indicate that you consent to be sentenced over Zoom?
Yes.
Okay, have the parties had an opportunity to review the sentencing guidelines?
Yes.
Yes, Your Honor.
All right, any changes?
Judge, I believe PRV 5, which is for misdemeanor, should be 2 points because he has 1 misdemeanor conviction.
Okay, any objection by the defense?
No objection, Your Honor.
So that means the overall change is to 47?
Yes, Your Honor.
Is it still a D level?
It is.
All right, OBs, I have 2, is that correct?
That's correct.
All right, is the guideline range still 5 to 23?
Yes.
Okay. Which is a straddle cell. All right, do the people have anything further they'd like to say at this time?
Your Honor, at this time, the people would move to dismiss count 2, and we would move to withdraw the habitual notice, third offense notice. I'd also say that I spoke with the victim, Mr. Eric Williams, yesterday, and provided him the information if he wanted to come onto the call and make a victim impact statement. It's my understanding he did not want to do that.
Okay. All right, I take it there's no objection to the dismissal of count 2 and the withdrawal of the habitual third, correct, Ms. Mitchell?
No objections, Your Honor.
All right, the court will dismiss count 2, withdraw the habitual third offense notice. Anything you'd like to say on behalf of your client?
Not at this time, Your Honor. I would just ask that you would dismiss the probation case.
Okay, we'll get to that one.
Okay.
Mr. Wade, anything you'd like to say on behalf of of yourself to the court before I impose sentence?
No, I am.
Okay, the court will sentence you pursuant to the sentence agreement, which my understanding is 3 years probation with the first year in the Wayne County Jail. There's 2 days jail credit, and you must comply with the requirements of drug testing directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. And you must present proper identification at the time of testing. You must participate in an adult education or GED program as directed by the field agent. You must comply with the Michigan Department of Corrections electronic monitoring program. Oh, wait a minute. Is he, gonna have a tether or does he have a tether?
I don't know that, Judge.
No, Your
You're
Honor, he does not have a
having
tether.
the tether on right now, do you, Mr. Wade?
No, Your Honor, I don't have no tether.
Okay, I don't know why. Number 3 is there. Does anybody know why number 3 is there?
I do not, Judge.
No, Your
Okay.
Honor.
The court is gonna strike number 3. You must not use any object as a weapon. You must not own, use, or have any under your control or area of control, a weapon of any type or any imitation of a weapon. And you must not be in the company of anyone you know who possesses these items. You must allow the field agent into your residence at any time for probation, supervision. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours per week. Unless engaged in an alternative program approved by the field agent, you must provide ongoing verification of employment or alternative program to the field agent. You shall not give reason to be terminated or voluntarily terminate your employment or alternative program unless you first obtain written permission from the field agent. There is no restitution, and you must pay $68 state costs. You must pay a crime victims assessment in the amount of $130, I'm sorry. You must pay a supervision fee of $720 as ordered by the court. Is that correct, Madam Clerk? The 720 supervision fee? It is? Okay. Also in here, it has that you must pay court costs in the amount of $1,300. Mr. Wade, do you have a job currently?
No, Your Honor.
Okay, I'm gonna reduce the, court costs to $300 instead of $1,300. And I'm gonna waive the attorney fees. It is my duty to advise you that you have the right to request leave to appeal from the Court of Appeals to appeal your plea and sentence. If you are unable to find an attorney, prepare your post-conviction motions or perfect an appeal. This court will appoint an attorney for you at public expense and will provide that attorney with such portions of the transcript as that attorney may require to prepare the motions or an appeal. You are further advised that if you wish to file an appeal or motion, the request for an appointment of an attorney must be made in writing and filed with the clerk of this court within 42 days of today's date. The clerk will email the advice of appellate rights form to your attorney, Ms. Mitchell, who will forward it to you. Does your attorney have your permission to initial the form on your behalf, acknowledging your receipt of the form? Mr. Wade?
Yes.
Okay. That is the form you must file with the clerk of this court within 42 days of today's date if you wish to appeal and need to have counsel appointed for you. If you do not wish to appeal, you do not have to send that in. That is your choice to make. At this point, Ms. Schoen, is he to turn himself in at Dickerson?
I'm sorry?
Is he to turn himself in at Dickerson or the Wayne County?
Either place, Dickerson would be best, yeah.
All right, Mr. Wade, you are to turn yourself in at Dickerson. It is probably, I don't know, what are the hours at Dickerson? Ms. Shaw, do you know how long?
Yeah,
Go ahead.
you know what, I would get there before noon.
Tomorrow.
Yes.
All right. Mr. Wayne, Mr. Wade, get there before noon tomorrow. Oh, tomorrow's Saturday, Ms. Shaw.
Monday.
Yes. Get there
Monday
by
would
noon.
be fine.
Yes, get there Monday by noon.
Okay.
So you got a weekend, Mr. Wade, to hang out, but don't get in any trouble.
I'm not. Thank you.
All right.
Okay.
Your Honor, we're asking that you dismiss the probation case.
Oh, at this time, the court will dismiss, close out the probation case that was tracking this one.
Thank you, Your Honor.
You're welcome. Anything else?
Nothing
No,
further
Judge.
on behalf of my client.
All right. Good luck to you, Mr. Wade.
Okay.
Let me have, we got one more hearing. Hold on. All right, last case is Drew.
Yes, I believe so.
But I don't see Mr. Drew on the Zoom call. Good afternoon, Mr. Upshaw. Oh, he's in there with you?
Yes.
Oh, okay. All righty. Are we supposed to have a witness on this?
No, Judge.
Oh, why did I think this was a hearing? Let me have, thank you.
Calling case number 20004154, the people of the state of Michigan versus Michael Drew. This is scheduled for a final conference. Appearances for the record, please.
Good afternoon, Your Honor. Andrea McCray appearing on behalf of the people, P number 83698.
Your Honor, Randall Upshaw on behalf of Mr. Drew. He's sitting here today with me to my left, P number 43574.
Mr. Upshaw, you are muffled. I can barely hear you.
Okay, Judge, what I must do then is point directly at me, then it should come in clearer. Is that clearer, Your Honor?
Yes.
Okay, Randall Upshaw on behalf of Mr. Drew, who's sitting here to my left, P number 43574.
Okay, my understanding when we were here last, I thought that the officer was supposed to be here. I thought we were doing an evidentiary hearing.
We are, Your Honor. Officers should be there.
That's what, yeah, that was the last thing, because we had gone through the motion, but there were some questions with respect to, Mr. Upshaw brought up, after there was a refiling, after the people looked at the video and indicated that he should not have been questioned, before the Miranda warnings were given. Then there was also another supplemental brief submitted by defense. And so I then sent out a question, or had my JA say, okay, are we still proceeding with this hearing after the briefs have been filed? And no one indicated, as far as I know, that we weren't. But the last time we were in court, the officer was supposed to be brought in because defense asked for a hearing.
Judge, so my understanding was that the last time we were here, the debate was over whether or not the defendant had gone willingly in his own car to the house or whether he had been formally arrested and was taken there by officers. My understanding was that he, and incorrectly so, was that he had gone there willingly. Now, when I watched the body worn camera and the video footage, it was clear to me, and which I said in my motion, my supplemental motion, is that he was arrested. So there was no longer a question of fact. So I don't on that. The
Yeah,
only
but-
issue.
But that wasn't the whole thing. You all had argued that. But what happened is, it then came down to whether the statements he gave after Miranda are statements that need to be suppressed as well. And there were questions as to, was he moved to a different location? Was there this break in the questioning? Did another officer do it? We didn't have those answers because we didn't have any information regarding that. And we brought up that we needed an evidentiary hearing. That is what we said on the last one, and that's what this next hearing was supposed to be for. And then the prosecution watched the video, found out that he basically was arrested and should not have been questioned, and conceded that. But the prosecution then said, well, but still the questions asked after Miranda should basically not be suppressed because he was given his formal rights. And even though I knew we had a hearing scheduled, since you had watched the video and made that determination, I then asked the defense if they were going to reply, which they did. Then I asked, was there any need for us to continue? At least I thought my JA sent out an email. But at the last hearing, it was decided that we needed an evidentiary hearing because there were many things we didn't know about the second statements. It's clear to this court that the statements made prior to the Miranda should have been suppressed because he was handcuffed. I'm sure he would think he was arrested and he shouldn't have been being questioned. But the court was not clear as to whether he should have been questioned, whether his answers after Miranda should come in or not, because there wasn't enough information on the record regarding the circumstances surrounding that. So we said we were going to have a hearing. That's what we had indicated.
Okay, Judge, well, I misunderstood that because my understanding was that we were only trying to determine like all these issues about the second statement. I didn't realize those were factual issues. I thought we were just having, a hearing possibly with a witness to determine if he was arrested at first. And so I have not subpoenaed a witness today. I did not think that was necessary because I conceded that he was arrested and that we agreed we wouldn't use the first statement made.
No, Mr. Upshaw made two arguments. He made arguments about the statements made before Miranda, and he made arguments about the statements made after Miranda. And so we said we were going to have a hearing. The prosecution did concede that the statements made before Miranda, he was arrested and he shouldn't have been questioned. But the people are still saying that the statements made after Miranda should come in, and the defense is still objecting to that. So that being the case, we do still need a hearing with respect to what happened, because it's a question of fact and law with respect to whether those statements are going to come in after he was Mirandized. There are certain factors that have to be gone through to determine whether that will be acceptable or not. Cipriano is the leading case on it, and we have to go through that to determine whether statements made after he was Mirandized should be allowed in or not. That's what Mr. Upshaw asked for a hearing at the last, that's what I have in my notes, that we're supposed to be having a hearing. So that's fine that we don't have him here today. We can reschedule it. Is that your understanding, Mr. Upshaw?
You are correct, Your Honor. I was expecting a hearing and because we have to have a
Mr.
hearing.
Upshaw, I talked to you on the phone. I talked to you on the phone after I saw these and I said, like, that is so inaccurate.
Okay, Ms. Crump, let me explain something you all respect.
It's Miss McCray.
I'm sorry. Okay, Ms. McCray, with all respect. I'm not going to, nor would I ever mislead anyone. You stipulated to the first Miranda that it was in violation, first confession. And that's why I even specified the whole issue. It's no good to have a half a Miranda answer question. It's about whether his statement is admissible. Anytime when a person schedules an evidentiary hearing, it's always a live person. That's the
Sir,
difference.
I told you I conceded, and then I said, so I don't think there's a need to have to call anyone now, right? And you said yes. And is there an offer? And what about gun board? And I'm going to submit a gun board letter. That's how we ended that conversation.
I'm saying this to you. If you want an adjournment, the judge is going to give you that adjournment. I'm not disputing. What I'm thinking is that seriously, with all due respect, you misinterpreted. I was always expecting, but if you need another date, that's no problem. The judge is giving you another date, but I would be foolish to go and allow this statement to be admitted. And the only way I can have it suppressed is by an evidentiary hearing.
Well, the only way that you can bring it before the court to ask for it to be suppressed. But Miss McCray, the court is going to caution you on your facial expressions and your attitude because it was unnecessary for the attitude that you just displayed to your opposing counsel. It was totally unnecessary. Okay? We're all professionals here, and it was very clear that you had a problem with what Mr. Upshaw was saying. And that is not professional at all. So, I don't know, I was not privy to the two of you all's conversation, but I actually had down that there was supposed to be a hearing. I will indicate that once I received your brief, I was wondering if that was going to exhaust the matter. But once Mr. Upshaw indicated, well, there's still the issue of statements after the Miranda, then he's right. If he wants a hearing on that, he can have a hearing. We don't know the outcome of the hearing because I don't know what the officer is going to testify to. I don't know if there was an actual break in the statements that were given originally, and then the second one, if he was moved to a different location and then given by a different officer, or whether he's been acquainted enough with the criminal justice system to know better. There are factors that need to be gone through. I had the same issue when I was a prosecutor with respect to taking statements and then turning around and getting the statement afterwards Mirandized and whether it was allowed or not. And there was statement, and the judge had to go through, and the defense gets the right to have a hearing if they want. So that's their right. He's representing client. That's what he gets paid for. So to have as much attitude as this court just witnessed by the prosecution is unacceptable. So it will be adjourned. Matter of fact, I have on here hearing right on the front of the outside of the folder. That's what I thought it was. So, matter of fact, when we came back on, Ms. McCray, I said, so we have 2 hearings today. I guess you weren't paying me any attention when I said that, because that's what I thought it was. And I do need a hearing with respect to the second set of statements.
How long does she need?
So, you need to get in touch with the officer. I understand that. Or officers, whoever was involved in taking the second statement. How many weeks, Ms. McCray?
2 weeks, please, Judge.
Okay. It's probably gonna be more than 2 weeks.
Yes, it's gonna be more than 2 weeks.
He got it.
What did you say I had on April 30th? How many matters?
You're full.
Oh, I'm full. Okay.
Yes,
May
May
5th?
19th.
May which day?
That's a Wednesday, May 19th.
What's on May 5th?
Let me see, May 5th.
It's not that many matters.
Okay, May 5th.
Okay, what I'm gonna do is I'm gonna set it for May 5th, but since it's an evidentiary hearing, I will make it for 2 o'clock. Is that fine with the party?
Yes, Judge.
Your Honor, I have an exam at 2:30.
Okay, on May 5th?
Yes, Your Honor.
Right, yeah, because I hate to do evidentiary hearings at the same time that we have the regular docket. It just takes too long. How many, May 7th, what is,
You have 19 matters?
okay, let's do, I don't hate to be here late on a Friday either.
Yes.
Let's, May 12th, how many is on May 12th?
That's a Monday?
No, May 12th is a Wednesday.
Oh, Lord, okay.
Yeah, I only do emergency.
You have 19 matters on that day as well.
Okay, let's do May 12th at 2 o'clock. How about that? Does that work, Mr. Upshaw, Ms. McCray?
Yes, Your Honor.
That works for the people. And Judge, if I could just be heard on one issue.
Sure.
I do want to apologize for the tone I took with Brother Counsel and Your Honor's court. I do apologize for that. I was simply just trying to explain what I understood my communications to be with Brother Counsel. I understand now that there seemed to be some kind of misunderstanding. I don't know from who, but I will just ensure that in the future those communications are, over email and written. But I do apologize to you, Brother Counsel, for the attitude and tone I took with you. I want to say too, Judge, that the last hearing with Your Honor, the last time we were here was with Judge Michael Hathaway, and he had said that he's ready to rule on this, but that he wanted to give Your Honor the ability to, actually rule on it because it was your case. So that's further why I did not have a witness here today. That being said, I understand that, he has the absolute right to bring a witness here to contest, the second statement. And so I will certainly have that witness, I believe it's the OIC that took that statement, present on May 12th, 2021.
Let me say for the record, Ms. McCray, that the last time you all were here, it was not before Michael Hathaway. It was before me. The time before that, it was before Michael Hathaway. You all actually argued this before me. It was on March when was the last time we were here?
That was a final conference on 3/26.
Right, March the 26th. Judge Hathaway has not been in the building since probably the beginning of March. That hearing was before me on the 26th.
I think he stood in for you that day, Judge. I think it was the 13th that we were here.
You all argued this in front of me, Ms. McCray. You were before Hathaway. Okay. He indicated to you that he was going to leave it to me. And then you came before me. And you both argued it. And actually, I was getting ready to rule when you were before me. And then some questions came up because actually the argument was, Brother Counsel changed his argument because the brief actually dealt with suppressing the gun, which I definitely would not have ruled for because they had a search warrant. And he said he did not write the brief. And you said, well, I guess it's a misunderstanding. Now that I understand you're only talking about the statement. Because I was getting ready to rule against him because clearly we're not suppressing the gun because they had a search warrant to go to the house, whether they stopped the car or not. That was the argument that was made before this court. I was sitting here and he told you that he didn't write the brief. And he doesn't really know what the brief said, but this is what his argument was. Do you now remember that, Ms. McCray?
Yes, I do, Judge. I remember all of that. And I remember that being on the early March.
Okay, well, you came before me on March. You've been here more than once in March.
Yes.
There were 2 dates in March. And the last time you all were before me. And I told you we were going to do a hearing. So, and when he said that, I was sitting here. So I don't know which time he made that, but I know I was sitting here. And I know Judge Hathaway did not rule, and he left it to me. I had every intention of not suppressing that gun for sure, because it was a valid search warrant. So it just didn't matter whether he was stopped in the street or not, because they would have gotten to the house anyway. And it would have been a doctrine of inevitable discovery. So that wasn't the issue until Mr. Upshaw then changed the argument and said, well, maybe not changed in his mind, but it was not the same argument that was put in that brief. So, and then it became apparent we were just talking about the statements at that point. So we will have a hearing on May, what day did we say now?
12th.
May 12th.
May 12th at 1 o'clock. I'm sorry, at 2 o'clock. Is there something you want to say, Mr. Upshaw?
No, and I just, I never try to have any confrontation. And Ms. McCray, if you misunderstood, with all apologies, I would never intentionally do that. And I would stand up for it if that was the case. So hope everything is fine, okay?
Absolutely.
And Ms. McCray, when I was a prosecutor, I used to always do my correspondence through email. I would suggest you do the same.
Thank you, Judge.
Have a good day, Your Honor. Have a good day, everyone.
You too.